David Clendon.
Thank you, Mr Speaker. Mr Speaker, I'd like to begin just by acknowledging and referring to the petition, which forms part of the report back from the Select Committee. Petition of Christopher Perry and 4,470 other ordinary New Zealanders who have signed their name to a petition that sought to have this House not impose certain reforms on the New Zealand Family Court. And I think it's significant. It's a representation of considerable public disquiet and concern about the direction that this bill is taking. I don't think there's particular concern at the fact of a reform or a review of the practice of the family court, but the way in which it's been carried out, the cost-saving focus, the fact that it will disadvantage many people, that it will reduce access to the court for many people, that it will give a less good outcomes for some of our most vulnerable citizens, not least of all our children. So the petitioners sought to get four key things. They sought to protect the right to a lawyer for parties in the court, and we have lost that, frankly. We have a qualified access to lawyers now, and that's very unfortunate for all sorts of reasons, not only because the right to legal representation is a constitutional underpinning, if you like. It's absolutely essential to our judicial process, and in this instance it is now being compromised. But also the fact that even if, to the extent that perhaps we might seek to take some cost out of the court, self-litigants in the court will slow the process down. They will impose cost on the courts. There will be significant cost, both personal and financial, when people try to represent themselves in the court, which they will typically do quite badly. The petitioners sought protection for lawyer for child. They wanted to see no barriers to the appointment of lawyer for child. And again, we have a qualified situation here where a judge may appoint lawyer for child, but it won't be as automatic or spontaneous as it has been up to now. And the children in this, of course, are the innocent parties invariably. They are not the ones who are having disputes, relationship failures, but unfortunately their interests will not be as well served as they might otherwise be. The petitioners sought the protection of legal aid in family court, and of course that has been reduced. And of course later this afternoon we'll also be debating the latest onslaught against the provision of adequate legal aid to people who might need it in order to be fairly represented in the courts. The final thing these petitioners required was to have no fee, no financial barrier to people entering the dispute resolution process. And unfortunately that does still exist, to the tune of about $1,000 or so, which is a significant barrier to many people. And of course that's only the beginning of the cost. So I think it's unfortunate that there seems to be a key presumption from some of the government spokespeople or speeches we've heard from government members on this bill, that we should, that the intention of the bill is to ensure that people sort out their own problems without recourse to the courts. But that's nonsensical in a sense, because as one of the earlier government speakers made the point, that something like 90% of relationship breakups, marriage failures, whatever it is, are resolved without recourse to the courts, albeit on occasion with using the counselling service, which is an extremely good value for money and an expensive way to assist couples to deal with their issues. But the notion that we are dealing with hordes of people who could otherwise deal with their own problems outside of the legal process simply isn't borne out by the numbers. 85 to 90% of couples do resolve their own issues without coming to the court. It's not a matter of an overuse of the court. In fact, it's underused, if anything. So by definition, the court only sees the hard cases, the difficult cases. The idea of requiring couples to go straight to dispute resolution rather than going into the court process rather overlooks the fact that there are a whole host of issues of its circumstances which may make that inappropriate, and some of those circumstances could be family violence, hidden family violence, which means that a person who has been subject to some form of physical or psychological abuse could be required to sit in a room and engage in a dispute resolution process, and that's simply unacceptable. On paper it might look nice and clear cut. In practice it won't work, neither will this bill, and we'll continue to oppose it.
Mr Speaker.
Louise Upston.
Thank you, Mr Speaker. I'm pleased to take the final call on the second reading of the